But one of the big questions that has come up is where does all the revenue go from all the certification fees that CARR collects? And I know that you guys think that Kevin and I primarily just have steak dinners every day for lunch, and our government cars are now like the new Tesla Model X's, but I promise that is not the case. So just so you know that the bulk of our funding comes in I don't want to say it's a grant. A couple years ago, we went to the legislator and said, look, recovery fees, I don't know if you guys remember back when certifications first started in 2020, recovery fees were $700 for the program and then $700 per house. And so you could be looking at a bill, if you had 10 houses, of over $7,000. And so with the legislator, we went and said, we would really like to make this more supported by state funding. And so they have put as a line item in the state's budget, $200,000. And so that is not a grant or something that has to get renewed or can go away. That is a line item in the state budget, so it would take legislation to take that away from us to be able to receive that money. So you guys can be rest assured that the fees, hopefully from that, will be subsidized by the state as much as possible. And then the next big pot of money comes from the $200 that we receive for every home that we inspect. And so that equates to just over $42,000 a year that comes in from the fees of $200. And the reason why it's not an even number, for those of you guys who have opened more than one house, what we try to do is prorate that fee so that we can keep you guys on the same schedule. And so if we have a program like Hazelbrook where we're doing 35 houses, if we were not to have them on the same time and try to schedule all those for different times of the month and different locations and driving all over the place, it would just be too challenging for us. So one of the things that we've done is to try to get you guys on all of the same schedule in that area. So I'm going to use Hazelbrook as an example. Again, they have a large portion of their population down in Colorado Springs and another large portion down in Denver. And so their dates, they have two different dates, but one's for the Springs, one's for down here. And so the reason why, again, why we do that is to make Kevin's job just a little bit easier. And then we do bring in $24,500 in 2022. All these numbers are based on 2022 data. And we bring in $24,500 last year, and that was on the number of programs different programs that we certified. So any of you guys that are slick on your phones can quickly do the math and say, okay, well, they charge $500, divide that by $24,500, and that's the number of programs in 2022 that were certified. But the big question is, well, where does all that money actually go? And so, as you can see, just over 50% of the certification fees does go to salaries. Those are the salaries for 2 individuals. And so as you can see there, it's about $124,000 that go to the staff of CARR. The other thing is, but take that number and divide it by 2. That's just not all Kevin's salary. So the other big number that you're going to see on there, one of them is that I want to point out is mileage. So you can see that in mileage, we spent $19,406 on reimbursement for mileage at 65 cents a mile. That means that Kevin and I roughly drove 29,855 miles in 2022 certifying recovery residences. So for those of you guys that are math geeks again, that's roughly 2,500 miles per month that Kevin and I are driving. I can tell you that last year I spent just over 60 nights in hotel rooms in the state of Colorado. That's probably why I'm in the middle of a divorce right now, but that's neither here nor there. No, I'm totally joking. Our other big expense, though, is on the conference. And we really value this time that we're able to come together and to be able to bring in speakers like Kim Savage and Lee Goldberg to be able to educate you guys on some of these zoning laws and the Fair Housing Act and the ADA and how reasonable accommodation, and I know that Dara is going to touch on this a little bit later, how reasonable accommodation doesn't just apply to you as a benefit, but that's something that you have to also pass on and recognize with the individuals that are in your recovery residence. Just of a show of hands really quick. Did you guys find today valuable for you guys as operators? Okay, fantastic. We will be passing out a survey during Dara's section, and that's going to be a survey question, but I was just out of curiosity to find out if you guys actually found this as valuable as we do, because we love it when one day a year we can all come together. I know that there's a Facebook group, and if you guys are interested in this, you can see Scott Muntz on our board, and him and some other recovery residence operators have gotten together, and I know that they do like a quarterly dinner and try to get as many recovery residence operators together as possible. And it's just a great time, but it's this one day where we come together as recovery residence operators to just be able to support our residents in recovery. And today's my favorite day of the year. The day before is my least favorite day of the year. Another big area is training. And so training, this is not just training for you guys, this is training for our staff to be able to better support you. And so Kevin and I have spent quite a bit of time in West Virginia, Ohio, Kentucky, and Virginia. Specifically, we spent a week in Virginia and West Virginia just seeing how they operate, how they look at their recovery residences, and how they do their certifications, just so we know that Colorado can stay on the forefront of how we're doing inspections and certifications here in this state, and so that we're providing you guys with the best data possible to be able to support our operators, which individually goes down to the individuals in our programs. And so there's where your money and the certification fees goes. Actually, before I go off of this slide, does anybody have any questions on this? Can you talk really loud? And I'll try to repeat the question.
Definitely can be loud. Insurance, is that like medical insurance for you two guys?
Okay, insurance is a great question. No, it is actually not anything to do with medical insurance. What we have to do is, I know that Lee talked about cybersecurity. Well, think about all the data that you guys provide to us. And we have, and just so you know, only CARR staff have access to the addresses of where your guys' recovery residents are, blanket across the United States. Now, I know the MSOs, you guys report those addresses to the MSOs, but that is probably the most closely guarded data that we have, because what we don't want is somebody to be able to target the recovery residences in, like, say, Lakewood or Colorado Springs. And so, so that's some of the data. But then we have the operators and the background checks that we've done on the operators and all that personal data and information. On top of that, when you guys pay your certification fees with credit cards. So a lot of it is on cybersecurity. We have a liability policy so that when we are doing inspections of your guys' premises, if something was to occur, there's protection for that. We've had situations where we go out to support the police department. When they have an incident at a recovery residence and they're doing some type of investigation of recovery residences, we will actually send out investigators with the police department, because if something was to happen, as the situation we had happen about a month ago, where an operator was potentially operating unethically. And if something was to happen to that operator, what we don't want to have is a recovery residence that the residents aren't supported. And so we went in to support the police department while they were dealing with the operator. We were working with the recovery residents to make sure that they were being handled and they were in a safe and secure environment. But if in those type of situations, if something was to happen, there's insurance to cover those type of situations as well. And so we have a pretty beefy liability policy And all of those percentages are dictated by the Behavioral Health Administration and the state on what levels of insurance we have to have. And then here again, it's if something was to happen as we were transporting staff to a recovery residence, or Kevin was to get an accident while he was doing certifications or things like that.
One more question.
Okay.
Earlier today, I think you mentioned Taylor, right?
Yes.
So he's not a CARR employee, he works for?
Okay, so I was about to get into that on the next slide. So we have 4 new employees that are covered under 100% of everything that they are doing is covered under the expansion grant from the BHA. And so at this time, their salaries through 2025 are covered through that expansion grant. So that's the reason why we didn't incorporate their information in there, because everything I'm about to talk about is all under that expansion grant. And so none of your certification fees goes to anything that I'm about to talk about. One more question.
How do I get involved in that group that you said meets for a meal?
Okay, so if you want to get involved in, I think it's called SLIC, Sober Living, Slack, Sober Living, help me guys. Okay, it's Slack. See Scott, he's over here with the Transition Sober Living hat on. See him, he'll be able to help get you signed up for that.
Is there an email address?
He'll come over and see you and get your information. Okay, any other questions before we move on any of the expenses that CARR does or anything like that? Because I really want to get into what we're about to do. So, just so you know, one of the things that CARR is going to be doing is we are going to be producing over 40 trainings. These 40 trainings are going to be micro learning sessions on things like the ADA, the FHA, the social model of recovery, insurance for recovery home. Lee is going to come back and not just do a session on insurance, he's actually going to do a session on, once you get your insurance certificate, how to actually read that silly document that nobody understands anyways. How to prevent MAT-related discrimination, overdose response, and how to respond to those. Kim Savage, who did the morning session, she is going to be doing a 5-part series on a lot of the stuff that she covered here today, but she's also going to go into things about house rules and making sure that house rules aren't discriminated against the individuals that are in the recovery program, and making sure that we're not, as operators, violating other civil rights that potentially we could be in jeopardy of violating. She is also going to be doing a session for municipalities. And so that if we have a situation, let's say Cortez, Colorado, and we have the municipality down there that doesn't want a recovery residence, she's going to create a session that we can point, that you guys, if you were to open up that recovery residence, you can point that local government to this session that's designed for them and to be able to answer those questions. And so now we're going to have essentially attorneys being able to help you articulate why a recovery residence doesn't fall under group home laws and is different than a treatment center. Because as everyone in this room understands that there's a difference between treatment and recovery, a lot of officials and community just don't understand that. The other one is community. She's going to be doing a session on community. So the other thing that we all know that's out there, and just want to touch briefly on how this is going to get addressed in 2024, is uncertified recovery residences. I had a conversation with Phil Weiser, who's the Attorney General for the state of Colorado, and he feels very strongly on uncertified recovery residences and them continuing to operate in the state of Colorado. And so he is going to have the Office of Consumer Protection work with CARR, and we are going to be having nice conversations with uncertified recovery residences. And the Attorney General's office has the ability to impose fees and fines where we're not necessarily set up in that way. And so just so you know that uncertified recovery residences will be addressed in 2024. So one of the other things that we are going to be focusing on very heavily in 2024 also is we want to really focus on the social model of recovery and kind of the things that Tony was talking about today. So your inspections, up until now, when we go in and we do your inspections, we kind of go over your policy and procedures. We really dig kind of deep into your physical inspection of your property. And so this was actually a strategic plan that was set apart about 2 years ago. It was set into operation. And so the first year that we started certifying recovery residences, we just wanted to make sure that we got people certified, that they were able to get funding through the MSOs, and we were playing catch up. At that time, I think there was 125 recovery residences in the state of Colorado. We had to get everybody certified, and I'll be honest, we were having growing pains and trying to figure out everything ourselves. At the same time, making sure that we answered the public safety cry that the community was addressing. And so that was the first year, and I think we've done a fantastic job with your support in being able to address that. Last year, we really focused on things like egress windows and screens. No, screens are Scott's big one. But we really focused on things like making sure that we have that fire smoke detectors met residential building code. All of the standards that we have as far as the way that your guys' programs operate are all based off of the International Residential Code. And so it's not something that CARR independently, except for med boxes, has come up with that standard on our own. And so that was last year. What we want to do for the next 3 years in this 5-year plan is to really focus on the 3 Ps. We want to focus on the people in your houses. We want to help refine policies to make sure that all the recovery residences in the state of Colorado are operating at the best possible level, and we're still going to be looking at that property. And the board is meeting tomorrow to kind of discuss what that looks like, because what we want to also be able to do is to go in and have conversations with not only with the operators of the recovery residences, but with the individuals that are in the house, so that we can make and ensure that all of the recovery residences that are operating, what they tell us they're doing is what they are already doing. Now, I will tell you, the individuals that are in this room are probably not the individuals that the second we leave, they move in the bunk beds into the rooms and are standing up bunk beds in these rooms, or that are saying, give me all of your lock boxes for your meds and we're going to lock them away so we have them for next year's inspection and they don't walk away. I know you guys would be shocked to know that some of those things happen. And so what we want to do is try to ensure, to the best of our ability and with your guys' support, that all of the programs that are operating in the state are operating at the level that you guys that are here today are. And so Kevin and Taylor, when they are doing the inspections this next year, are really going to focus heavily on the people in the houses. On top of that, when we're reviewing the policies, like if there are improvements that we can make, we're going to make suggestions to you and work with you, or if there's questions that you guys have on how do I handle this situation, we want to spend the time with you during the inspection process to be able to make sure that we're supplying you guys with the best possible support that we possibly can. So this is a big one. We have funding to support a license for all recovery residence operators in the state. And so if any of you guys have talked to programs like Sobriety Hub or Behave, Get Help, One Step, or some of the other recovery resident software out there, one of the things that we're looking at doing is purchasing a statewide license. And the reason why we want to do this, and we feel very strongly about doing this, is we want to be able to prove the validity of recovery residences. And so if we're able if we're able to go out there and support support you guys with software that is a benefit to you and no longer an expense, and that software is to give us data back. And here when I say we're getting data back, it's not on your individual residence. It's all going to be, we're going to ensure that it's all HIPAA compliant and that data is given back to us in such a way that we will not be able to identify a particular individual. But SAMHSA is about to release a study that says that recovery residences have a greater impact on somebody's recovery than a treatment center does. So that dollar for dollar, that if we were to put somebody in a recovery residence, if that same investment that they put into treatment was put into somebody into a recovery residence, the chance of them having long-term success and sustained recovery are higher in what you guys are doing than what a treatment center is doing. But we have to be able to support that. So one of the things that but at the same time, if we just ask you guys for data, let's be serious. The last thing you guys need is another burdensome thing to do. So what I want to do is to partner with a company like Behave or Sobriety Hub or One Step or Get Help that have already created bed tracking software. And they have all of the stuff that a lot of you guys are already utilizing. And to be able to give you what you're already utilizing, but to add on to that 2 other components. One of them would be that data collection, and the other component is the measurement of an individual's recovery capital index. And who here in the room is familiar with the term recovery capital index? Okay, so a few of you. Okay, so quickly let me, I'm going to give you like a 60,000 foot overview. So what we want to do is use some of these tests that are out there and create it in such a way that it's fun for the individual to utilize this. And so what we're going to do is ask them questions every day. I'm asking them like 1 or 2 or 3 questions that kind of pop up on their phone through an app. And what this is going to do is it's going to measure where they are in their recovery at this time. And so if an individual is not engaged in their community and is being detached from the community, from that baseline, we're going to be able to measure, and it can kind of be on like a stoplight system. Red, we got a problem. Yellow, okay, they're about to have a problem. And green, okay, this is not an area that we need to be concerned about. So if you have your house managers or your peer coaches or individuals that are working with these individuals in your house, and every day they're answering these questions, and all of a sudden they go from having a green stoplight to a red stoplight, well, we know that there's potentially a return to use could happen in that situation. And so what a recovery capital index is going to do is it's going to measure different sectors. Your community involvement. How are you doing in your own sobriety? How are you doing with your financial stability? And it's going to take all these indicators that are evidence-based, and it's going to allow us to, at your guys' level, to be able to ask these individuals these questions, which is going to give you guys real-time feedback on how your residences are doing. And so, and this is great for you guys also, because if you guys can take somebody and reduce their return to use in your house, then that's another bed that you guys potentially don't have to turn over. And so I'm hoping that there's a benefit not only to us and being able to report data, but to you guys as operators, because I know a lot of you guys that use some of these systems, some of these bed management softwares can cost up to $10 a bed per month. And so if you have a program that's over 100 beds, I mean, that can be very costly for a recovery program every month. And so what we're trying to do is, through using the consolidated buying power of all of you to be able to get a statewide license, to be able to support you with that, but at the same time to be able to finally get some data that is evidence-based that we can use through a third-party evaluator to be able to prove the efficacy of recovery residences. So if you are interested, and that sounds like something that you're interested in, or you guys use a particular type of software and you're like, I really don't want to change my whole system, join the committee, reach out to CARR or the staff today so that you guys can participate in that. We've already voluntold, I guess Heather has already left. Heather over at Signal to help us out with this. And so there's going to be, I know that the BHA's IT department wants to be involved in this committee. So if this is, you've always wanted to figure out a way to get involved, this is a way to get involved and to for the first time to have some input at a pretty high level on what's coming down to the recovery residences. I'm going to ask Taylor to actually talk now. Taylor Wright is our Director of Rural Area Expansion. And so Taylor's going to come up here and talk briefly about the expansion efforts that we are doing here in Colorado.
Afternoon, everybody. My name is Taylor Wright. I'm the Director of Expansion and Development for CARR. Hi. I'm also a person in long-term recovery. That actually comes way before any of my other titles as director or whatever else. So as far as the goal, CARR has undertaken a goal to expand the number of recovery residences throughout the state, particularly in the rural, isolated locations, communities in Colorado that are vastly underserved in terms of clinical care, in terms of housing, and different things like that. So one of my major objectives is to hopefully partner with some of you to take a look at what we can accomplish between a partnership and getting those resources, those housing resources, out into those areas that don't have them. My information is up there. If you have any interest in doing this, please come find me after this. Come find me before the end of the day. You can contact me by phone or email, and I'm happy to discuss that with you. I've got a brief amount of time, so I'm trying to cover as much as I possibly can. So some of the obstacles, as probably most of you know, in opening new recovery residences is a cost. Sometimes when construction comes into play, or adding egress windows, furnishing a recovery residence, that can be a hindrance to your financial situation. Through this grant funding, we have an allocation to support those things, to provide construction for the internal property itself, the physical nature of the property itself, the egress windows, even first and last month rent, as well as furnishings and things like that. So just to help, it's a bit of a show of good faith as we look at adding additional resources to these communities to assist you in that way. Just to outline a few of the benefits in working and partnering with CARR on this. A little bit of my background. Before I came to work with CARR, I did work for Oxford House. So networking with that in the community, locating residential properties that are suitable for recovery residences, and really tying in the recovery community, something that I do have a lot of experience in. It's particularly important when you get into rural locations that, for the most part, not all of them, but they're fairly segregated in terms of the care that they provide and how they work together. So one of my goals is to tie that community together, have it work with the recovery residents that is in that new community, and create the ties that bind, create referral sources for the recovery residents, help you with structure if you aren't certain the direction that you want to go with that, and then we make it all happen together. So you have a close partnership, particularly with myself and CARR. In addition to that, we would make sure that the house from the get-go meets CARR standards. So just a general outline of what that relationship would look like and how we would support that. Happy to take any questions. Running short on time, like I said. If you're interested, please come and find me afterwards, and I'm more than happy to go a little more in depth with you, and we can talk about this further. Thank you.
Thank you, Taylor. Okay, so that's kind of the nutshell of what you can expect from CARR in 2024. There'll be more information that's going to come through the newsletters on some of the nuances of some of those changes. One of the big things that has changed that we kind of touched base on just a little bit was some of the new legislation that we spoke about briefly last year. And I'm at this time going to invite Dara Keller, who is the general counsel for CARR, to come up here and put her on the hot seat to answer a lot of the questions, kind of go over the new legislation and some of the new, the legal side of some of these impacts of the legislation and what that means to you as operators. And then if that's okay afterwards, I'll come back up and Dara and I can answer questions that you guys have on anything that CARR is going to be doing in 2024. So if it's okay, I'm going to turn it over to Dara Keller now.
Great, thanks, Butch.
And then this should work to advance. If not, these.
Okay, perfect. Thank you, Butch. Hi, everyone. My name is Dara Keller. I'm General Counsel for CARR. Thanks for sticking with me this afternoon. So I'm going to be talking about some changes to laws, policies, some issues that we've been dealing with over the last year that we think is really important for you guys just to be aware of. And then, of course, we can answer any questions that you have. If you have a really specific situation, we might need to defer. Again, I can't give legal advice for specific situations. This is all just general educational information. So my little legal caveat already. All right, so the main topics I wanted to touch on, first, the medical cannabis policy. I know we got a lot of questions about this, so we're going to talk about that a little bit more. Reasonable accommodations. Kim Savage gave a fantastic presentation this morning about some laws under the Federal Housing Act, the Americans with Disabilities Act, Colorado law, and so I wanted to touch on something a little bit narrower on how that as far as recovery residences and residents who might have disabilities in addressing those. The discharge and transfer bill, and then privacy protection laws, namely HIPAA and Part 2. Okay, first up, the medical cannabis policy. So this is the text of the actual policy. You might have seen this already. I think Butch might have sent around a copy. So I'll give you a minute to read this. You can't see it? It's too small. Okay, I tried to fit it all on one slide. It might be on the website too. I'm not sure. Is it? Okay, it's available on the website as well. Essentially what this says is that if a recovery residence program wants to offer medical cannabis as an option, these are the guidelines that you have to follow under CARR. Okay, so some frequently asked questions that we've gotten. Do I have to allow medical cannabis in my recovery residence? No, you do not have to allow medical cannabis. This is an option. If you're going to allow medical cannabis, then you need to follow these guidelines, but it's not required that you do. So if you are an abstinence-only program or a MAT-only program, that is totally fine not to offer medical cannabis. Medical cannabis is not considered one of the MAT substances. Does this mean that residents can smoke marijuana at the residence? No. Even if you offer medical cannabis as an option, under the guidelines, the CARR guidelines, it needs to be in a non-combustible format. That way you have a little bit more control over that. Okay, my residence allows medical cannabis. What are the requirements for a resident who wishes to use it? Okay, here are the main requirements. Number one, they need to be prescribed medical cannabis by their physician. So here I use the word prescribed. This is kind of a legal technicality issue. Cannabis is still federally illegal, as I think everybody knows. So technically physicians can't quote unquote prescribe it. They recommend it. Here I'm using the word prescribed because that's kind of how everybody understands it, right? So. Number two, they need to be registered with the Colorado Medical Marijuana Registry. And number three, possess a current medical marijuana card, certified by a qualified healthcare provider, issued by CDPHE. So they need to actually have that card. So if you're going to offer medical cannabis, make sure you're meeting those three requirements, or that your resident is meeting those three requirements. Okay, what about residents that don't want to use medical cannabis? So if you're going to offer it in your house, all of the other residents must be informed that your house allows medical cannabis, as it might not be a good fit for everybody. And then if a resident's use of cannabis is interfering with either that resident's progress or any of your other residents' progress, then you just need to take that into account, and it might be best for the resident to maybe move to a different program, talk to the resident, talk to all the other residents, but it's something that you do need to address if it's a problem for either the resident using the medical cannabis or the other residents in the house. Okay, so I want to pause for a second. Does anybody have any questions about the medical cannabis policy? Kaylee?
Okay. If you receive federal funding, are you allowed to have cannabis in your program?
Great question, thank you. So no, if you receive federal funding, you cannot allow medical cannabis. The reason for that is because it's still illegal federally. So if you're getting federal funding, then you can't allow cannabis, at least right now. Right now, there's a movement to make it legal federally, so that may change in the next year or two, but that's the status. Okay, any other questions? Yeah.
You say non-combustible, does that mean they have to do edibles or something like that?
Yeah, so any non-combustible method, there's a few different ones. So that could be, tablets or, powders. Yeah, anything that's not that. Yeah, oils, anything that, especially where you can measure it. So that's, one of the things that you want to keep in mind is what the physician is prescribing, and to make sure that the amount that the resident is using is what's being prescribed. So if a resident does seem to be abusing it, overusing it, things like that, then the house or the operator does need to take action. Speak with the physician, speak with the resident, and that might mean.
In other words, if the prescription says 2 pills a day, then they can't take 4 pills.
Right. So the question is, if the prescription is for two pills a day and they're taking 4, that would violate their agreement with you, the residents. So that could be,
So it's just dispensed with the other medications.
Right. Exactly. It's treated the same as other medications.
So would there generally be a recommendation for dosage if it's not something that's technically prescribed?
That is a good question. I think it might depend on the physician, but that is something that you probably want to speak with the resident about. Get a release from the resident to talk to their physician about. If you need more information, it's fine to say, okay, I need more information to understand what you're being prescribed or what's appropriate for you. But you will need a release from the resident to talk to their physician. Yeah. Yeah, so, we struggled with this a little bit, but we understand that it is becoming more common, more recognized as a method of treatment, and it might not be for everybody. But we wanted to, CARR as an organization wanted to get ahead of it so that, if this is something that's going to become more popular or more utilized, that at least there's guidelines in place. So, to make it as safe as possible.
Yeah. What are your suggestions if you're not allowing it to be combustible? I would go further to say, or ask, are you allowing flower or buds, the actual tangible, really smelly stuff?
So, and Butch might be able to answer this more. What we're envisioning is something like tablets, oils, something like that, where it's more like a medication.
Right. So I guess I'm asking, like I have some resident who is a recovering meth user, and I look at it as kind of much other than smoking weed than meth. And so 100% on how to navigate that, and I suspect other people have this question, so that's why I'm like,
Well, number one, it does need to be prescribed by the physician. And they need to, have that medical cannabis card, be registered with CDPHE. Butch, did you?
Yeah, it has to be measurable. That's where it's really going to come down to, measurable and monitored. To answer the other question, just to add on that, why the change, we have 5 programs in the state of Colorado now that were allowing medical cannabis in their programs. And so want that, and if you notice that when our policy came out 2 days later, the White House released that they were going to move to make it legal federally and to take it from a Schedule 1 to a Schedule 2 substance. And so, Schedule 2 or Schedule 3, I don't remember. And so that was another reason for the change. We had a heads up from the White House that that was about to be released. And so that's when we had this policy ready so that we were ahead of the federal release. Now they still has to go through the election process and all of that. But with the already 5 residences using this medical cannabis, and then on top of that, the change federally, we had to enact a policy here in Colorado. We couldn't just allow it to be uncontrolled or unregulated or unsupervised anymore, because it was beginning to have an impact on some of the operators. I would say a majority of the operators that are abstinence-based from substances like this. And so what we didn't want it to do is to have an impact on you guys.
Thanks. Any other questions? All right, so I'm going to move on to reasonable accommodations. Kim Savage gave a really great presentation earlier today about federal housing laws and Americans with Disabilities Act. So I wanted to talk about a more narrower topic on what if you as a recovery resident, what if you have a resident come to your program who does have a disability? Hopefully you guys can see that. Okay, so the picture I have up here is equality versus equity. And so this is what it really boils down to. You might have someone come to the residence and say, look, I don't discriminate, I treat everybody equally. But what you really need is not equality, but equity. So, I give everybody the same bike, that's equality. Well, equity is recognizing that people are different. They have different abilities, maybe different impairments, maybe need a different bike. So the example I have up here is if a resident comes to your recovery residence and is diagnosed with severe ADHD, they've been treating with their physician, they have a prescription from their physician for Adderall. And you say, I am an abstinence-only house, I don't allow Adderall in my house, I don't allow medications like that in my house. You may need to provide this person a reasonable accommodation, which might mean for this individual, because they suffer an impairment and they need that Adderall for their impairment, in this one individual case, I'm going to allow it. So this is very, very much a case-by-case basis, very fact-specific, just something to keep in mind, that if you ever run into a situation like this, you might just want to take a beat and think about it, maybe consult with an attorney, maybe call CARR, because there are situations like that, and we've seen situations like that. Okay, do I have any questions about reasonable accommodations? Yeah.
Well, isn't having a drug addiction a disability?
It can be when you're in recovery, but by the very definition of, it's only a disability if you're in recovery. So if you're actively using, that's not a disability, and that's not an accommodation. But that's not a reasonable accommodation. What has come up, or what I have thought about as well, is what about cannabis? What about, let's say not even for recovery, but someone has a severe back injury that they've had for a long time, treating with a physician, and the physician has recommended medical cannabis. Is that a reasonable accommodation? It might be. Again, very fact-specific inquiry, but even in situations like that, it's something you might want to pause and think about when it's a medically recognized treatment. Any other questions? Okay. Okay, so new recovery residence documentation requirements. This is an update to the statute that governs CARR and governs recovery residences. And up here at the top, you'll see a citation to the statute. It's CRS 2780129. So I recommend everybody just take a look at it and read it. I'm going to kind of hit the highlights here, but it's good to just go through and read it. It sets out the requirements really specifically. So highly recommend doing that. And this was a new bill or amendment to the regulation that just passed this year. I think it went into effect in August maybe. But here's the documentation that you need under the amended regulation. So first you need a signed program agreement. That's an agreement between you, the residents, and the resident that outlines the requirements that the resident needs to follow, including a drug screening policy, a code of conduct that prohibits the use of alcohol and non-prescription or illicit drugs, and notice that the resident could be immediately discharged for possessing alcohol or illicit drugs. I'm going to talk about that in just a second. So the second document that you need is a relapse plan. That plan outlines the steps that the recovery residents will take to evaluate and return a resident to the house after a relapse. And then finally, the client discharge and transfer policy. So this was a big one. CARR had worked on really hard this year to help all of the recovery residences. I know this has been an issue in the past that has caused a lot of headaches for a lot of people. I think a question was raised earlier about a resident overdosing and needing to evict them, and what do you do? Well, now under this amended law, you now have authority to be able to discharge that resident without having to go through the eviction process. So you can discharge or transfer a resident with 24 hours notice if the relapse plan has failed and the discharge or transfer is necessary for the resident or because the recovery residence is unable to meet the needs of the resident or the resident returns to using drugs or alcohol. So when we're talking about safety here, it's not just safety of the resident who relapsed, but also safety of your other residents. So just something to keep in mind. If that resident's relapse is causing safety concerns for your other residents. The other big part of this is that in addition to that, the 24 hours notice, a recovery residence may also immediately discharge or transfer a resident if the resident possesses alcohol or drugs at the house. What you do need to do is document the discharge and referrals made. So this isn't just a CARR policy, this is actually in the statute, what you need to document. So when you're drafting this policy, again, look at the statute and just add that to the policy. So prior to the resident vacating the residence, staff need to document the basis for the discharge, provide the client with referrals to treatment and social services if they need that. So things like housing, food, if there's food insecurity, things like that, if the resident needs that and if it's available in the community. And provide the client with a number to the Colorado Crisis Hotline. There is an appeals process through CARR, so a resident can appeal their discharge or transfer through CARR. There's a due process through CARR that they can do that. And if they have questions about that, again, they can call CARR or submit a grievance, and and we'll go through that process. But this is really for the recovery residences to give you the tools to respond to those issues. Okay, any questions about the new policy? Yeah.
So I guess my question is.
Hold on one second.
Don't make me do that. Sorry. I guess the question for me is are those the only reasons you can discharge somebody? I mean, like if somebody's a chronic rule breaker or not coming in before curfew or, things like that.
Under the statute, yes, basically relapse or safety is kind of the big ones. that you can do either immediately in the case of if they have those drugs or alcohol, at the house, or with 24 hours notice. For other issues, you might either have to go through the eviction process, and Butch, maybe you can speak more to this. I'm not sure the process, but it's not covered under this statute. So if there's an issue with them, as a tenant, you might have to go through a different process, like the eviction process.
1 second, Linda. Okay, so I know that when she used the word eviction, like, I could feel the visceral reaction that you guys all had in the room. Attorney? Realist? No. We all know how recovery residents operate. The reason why we push for this bill, to put all the language in this, we would have never gotten it to pass. I'll just be honest with you. This was one of the most contentious bills down at the Capitol that was able to get passed this last legislative session. And I really wish Representative Lindstadt was able to be here. Yeah, unfortunately, there were some time restraints, and he wasn't able to speak to you guys because he was going to address some of these things. The answer to your question is you can still discharge somebody. The eviction process, the bill was designed to help with a situation where somebody has a return to use. This is a situation that I actually got a phone call on, where I had a police officer standing next to an individual in a recovery residence, and the individual had a case of beer and was drinking a beer and offering it to the police officer and everybody else in the house. It is legal to drink a beer in your house. If you're not in recovery, that is completely legal. I mean, even if you're in recovery, you can still drink the beer in your house. It is not safe to do that in a recovery residence. We all know that. It is even more unsafe for them to be offering it to the other residents in the house. The police understand that. Unfortunately, the police hands were tied because this was a civil issue. And the eviction process would have had to been followed because that is a completely legal issue. So this law was created in a way to allow us to discharge or transfer. We're having to use those words, discharge and transfer, because when we said things like, we need to kick the people out, they didn't like that. They also did not like the words when we said the word, we want to remove residents' rights from an individual, because the state of Colorado has been, for the last 3 years, increasing residents' rights on individuals. So this was looked at from a very clinical component and making this a program issue. Now that is in conflict with the Fair Housing Act and ADA and all that, because we as operators all know that a recovery residence is essentially a single family home. So we had to be very, very careful in our language not to compete with the protections that allow us to operate. And so that's why the word program is never in here, because the second we become program, now we're moving into the world of group homes. And that takes away the reasonable accommodation for you guys to be able to operate as a family unit. And so you can see the nuances that we had to kind of thread in this, because just in what I've said right now, operating as a family unit. Well, if you're operating as a family unit, you have to evict somebody. Well, we didn't want to have to evict somebody. We didn't want to be able to move them out immediately. Well, now we're a program. But if we're a program, you're not a family. You're a business. So reasonable accommodation doesn't apply. So you can see how I'm just like jumped in like 30 seconds back and forth on the side of the fence on this. And so it's very, very nuanced. And so what Dara is trying to give you are the steps that you guys have to follow, that if somebody is really, really causing catastrophic problems to your homes, how we can utilize this law and have the conversation with the police and be able to remove that individual from your house so they don't cause more harm to the other residents in your house. I'm going to let Charlie, Mr. Keys here, he's with the city of Aurora, ask the next question.
And it's not a question, it's just really a recommendation for you guys. And I'm the licensing investigator for the city of Aurora. And I deal with kind of on the back end, everybody that doesn't like you guys existing. When people come and, want to raise pitchforks and stuff like that, those come my way. Those come to me and my boss. We really work to educate folks the neighborhoods, et cetera, about you guys as a big picture, and that you guys are allowed and not going to implode their neighborhood like they believe. And so the only thing I'd like to really recommend to you guys, just to make life easier for you in that situation, is have a copy of that statute. You know, you guys all have books in your houses that have regulations and rules and stuff like that. Have that be one of those documents you have in there, because I will assure you right here, right now, that you call the police for help with dealing with and getting that person out of your residence, and they're going to say, that's a civil issue. We have nothing to do with that, right? And you're going to have to say, no. Under state statute, they're in violation of state statute, and I need your assistance. You may have to ask them to get a supervisor on scene or to call you, so sergeant, lieutenant, something like that. And with the state statute, what they will do is they're going to, if you've got a copy of it, right, they can read it and say, oh, yep, sure enough, and then they'll be able to help you better. So my one recommendation is have a copy of that, because I talk to the police all the time, right? I talk to the police in Aurora all the time, and they're like, hey, we're having problems here. Hey, they called us about this. And so I educate them too, and I'll take this specific state statute back to them and help start to educate in Aurora. But have a copy of that so when those officers are responding, it's not a civil matter, and it'll just make them helping you a lot easier.
Yeah, the internet, we're going to put it out there. We're also working with municipalities and the police departments on educating them on this. We've actually had this come up a couple times already in Aurora. And so the police have been amazingly responsive to be able to support you guys on this. I'm not positive it's on the website right now, but if it's not, we can definitely make sure it is.
So my question is, a lot of the times, and I know a lot of other operators and owners have dealt with this, when clients relapse, they typically just leave. They don't want to be in an environment where everybody is sober and doing good, with the shame and the embarrassment of the relapse. So in situations like that, are we still are documenting after the document of discharge and referrals? We still have to do that, or is this worst case scenario they're not wanting to leave?
By the letter of the law, it all still needs to be documented.
Okay.
And I will tell you, and I think Dara will agree with this, document everything. Just document.
Okay.
Yeah, and documentation really helps us too at CARR. If there's ever a grievance filed, if you have documentation, it just makes it a lot easier and a lot smoother on everyone. Yeah.
What all information pertaining to the discharge client needs to be included in that document of discharge?
So that is actually in the statute, and I didn't want to load you guys with too much information. But yeah, if you just go read the statute, it tells you what you need to document. So just copy paste that into your policy. Yeah.
At our facility, we've had situations where we've had to have people leave for reasons other than relapse. There's a giant hole in this. It's basically, according to this, if somebody relapses, if they're having a mental health breakdown, they're threatening people, they're destroying the house, that would be a reason, of course, for discharge. But according to this, we have to give 24 hours of notice for that. So who's going to watch that person for 24 hours while they continue to threaten our residents, destroy our house? There's a giant hole in this. Is anybody aware of that?
Okay, you're not going to like my answer on this one, Linda. This was a concession that we had to get the law passed. So you have to remember, before this law, that person was going to have to be able to stay in your house for 60 to 90 days while you went through the eviction process. Now it's 24 hours. I know that nobody in here likes to hear that. I know that nobody in here is going to abide by that. Yeah. That is your. Well, he won't be able to remove them for up to 90 days when you go through the eviction process before. The other thing is I would recommend, if you're concerned about the 24-hour clock, email us. A lot of us know that something like this is going to happen ahead of time. Just shoot CARR an email, and that way you've documented the 24-hour clock also, in case you have a resident that you really are concerned about. Call the crisis unit is another great one. Okay.
Okay, so my question is also along with the 24 hours notice. So according to this, if someone is in possession of alcohol or drugs, that's grounds for immediate discharge. Currently in our program, if someone is high or drunk, that can also be grounds for an immediate discharge. Does that still follow, like, does that still work along with this protocol?
Can you put your earmuffs on for a second? I can tell you, we are going to do our best to support you guys. If somebody has a return to use in your house, we are going to do everything we possibly can to support you in the discharge or transfer of that individual. There was no way that this was going to get passed with the way it was. Without having that 24-hour concession, it just was not going to get passed. So we had to weigh what was more damaging. Having that person that had a continued return to use in the house for 60 to 90 days, or giving them the concession of 24 hours. So.
I think the difference here is if somebody's harming people in the house, harming my property, it goes from a civil matter to a criminal matter, and you call the police. It's not a civil matter anymore if you're breaking my furniture. It's a criminal matter, and we're going to press charges to get them out of my house. Plain and simple. That's how it is. They will do it.
So I've talked to Scott briefly about this, just like, I don't know, I remember we talked on the phone about like, how does it go with like program fees, rent, like, and whatever you want to call it, and having to dismiss somebody from your program for being behind on their program fees. How does that apply with this? I mean, I kind of know a little bit from talking to Scott, but just so kind of everybody knows what the deal is.
So, again, the statute doesn't address that. So, again, we go back to the whole question about program fees versus tenant and rent. A program, essentially a contract, it's agreement between you and the resident. They're going to pay X amount of money for attending your program, and if they don't, then they're breaching that agreement. Whereas on the other side, you have tenant laws and rent, and if someone's not paying their rent, then you go through the eviction process. So again, kind of a gray area, very case-by-case sort of question, but not addressed under this statute. This was really directed at the situations that CARR had come up several times where dealing with relapse or safety of other residents.
Now, the one thing that we can do in a situation like this is we can create standards around that if we need to. Now, as far as refunds, that was kind of one of the questions that you're going to. All that CARR does in review of your policy and procedures is to make sure that when you discharge or transfer somebody, you follow your refund policy that you have stated. I'm going to guess that almost every single person in here says, we don't give refunds if you have a return to use in our program. We will completely support that, if that answers your question.
What about if somebody's do they go into the 24-hour thing?
That would be a civil matter, right? Yeah, if somebody doesn't pay, that would be a civil case that you could bring up against them.
It's like breach of contract.
Yeah.
Yeah.
But are we allowed to ask them to leave because they are not following the contract that they signed that said that they would pay their program fees? I guess I don't understand that.
So that's a great question. I actually brought that up with the person that sponsored the bill, and that was a hole that was put into the bill that needs to be addressed and cleaned up, to be honest. So the question was asked, if somebody isn't paying, can they be removed from this? And the way that we understand the bill, and we being myself and the gentleman who wrote the bill, is that that is a hole that accidentally got put into the bill because it specifically says that somebody can't be removed for non-payment, and that was not put in there to say you have to keep somebody in your house forever if they don't pay because now you can't evict them, and this bill says you can't kick them out. What that was put in there for is that saying that you can't immediately kick somebody out if they don't have payment.
But even if the contract that they sign says that if they do not pay their program fees, then they are asked to.
I think that you would be okay with doing it that way, under the contract, yes. Do we have any other questions? Of course. Well, we need you to do the microphone for the recordings.
Oh, okay. It's like, I can voice very loud. It's not a question. I just want to say that I know how hard you guys worked on this, and thank you to CARR for putting this in place because it is a level of protection that we did not have as operators beforehand. That's all. Thank you.
Thank you. We really appreciate that, guys. Do you have another more slides?
I do. I have one more slide on privacy.
And then we'll open it up for questions on anything.
Yeah.
Maybe.
So I just have one more topic I wanted to touch on, which is protecting residents' health information, or private information. So 3 primary laws here: HIPAA, 42 CFR, Part 2, and Colorado law. So as Kim mentioned earlier, there's a hierarchy of laws: federal, state, and then local. HIPAA and what's typically referred to as Part 2 are federal regulations. Those are a floor, not a ceiling. So states can always implement laws that are stricter than HIPAA in Part 2. Colorado does have specific laws that protect personally identifiable information, which is typically referred to as PII, as well as health information. So that includes medical information, substance use disorder information, and then a few other things like HIV, AIDS, genetic information. The Colorado laws, and I didn't list them here because there's a different law for every category, but they generally follow HIPAA. So if you're following HIPAA, you're going to follow Colorado law. Yeah, I know. Nice when that works out, right? Do these laws apply to you? So there is an analysis you can go through with HIPAA and Part 2 to figure out, do these laws apply to me? So HIPAA only applies to covered entities. Part 2 applies to substance use disorder programs. And there's legal definitions of both of those. But I didn't go through that because even if they don't apply to you, they can apply to the information. So for example, for Part 2, which is the one that I really wanted to talk about today, because that is the law that protects substance use disorder information. Part 2, those laws, even if you're not technically a Part 2 program, if that information, Part 2 information is shared with you, it follows that information. So those protections follow that information, so you need to be cautious disclosing any substance use disorder treatment information outside of your program. Okay, the general rule is that you shouldn't disclose information about a resident's health or treatment unless you either have their written consent or an exception applies. Okay, again, HIPAA has a ton of exceptions, and you guys would probably fall under one of the HIPAA exceptions, but here I just wanted to touch on Part 2 because, again, the information that you're dealing with is probably going to fall under Part 2. And to clarify, so HIPAA and Part 2 both apply to this information. Part 2 is stricter. So that's why I keep referring to Part 2, because again, if you comply with Part 2, you're going to comply with HIPAA. So this is a list of all the exceptions under Part 2. If you don't have one of the exceptions, you need to have the resident's consent to share any sort of treatment information. So that would be any health information that identifies them as a substance use, as an individual who currently has or in the past had a substance use disorder and is related to their health information. So things like UAs. If you have those test results and you want to share that outside of your program, you're generally going to need the resident's consent to do that. The exceptions, and the ones that I have bolded are the ones that are most likely to apply to recovery residences. So first, the criminal justice system. If the individual was referred to your program and for monitoring, so from the criminal justice system, probation, the probation officers require information from your program as part of that, their probation requirements, you can share that information without the individual's consent. The second one is medical emergencies. So if somebody relapses, is having a health crisis, and you contact medical services, you can share their information without their consent. And then finally, court order and a subpoena. So this one's a little bit different than HIPAA. So HIPAA generally, if you got a court order under HIPAA, you supply the information. Part 2, you need both, court order and a subpoena. Okay, so for anything else besides those exceptions, you would need the resident's consent, a written consent to share that information. This is what the consent release form requires. CARR has a compliant release form on the website that you guys can use. So that's probably the easiest place to get it. But you do need to list who's providing the information, which would be you guys, who is receiving the information. It can list multiple parties, so that was a pretty recent change under this law. So if you're sending it to more than one provider, let's say the resident wants you to send it to an IOP program and their personal physician and a few different people, you can include all of that on one release. That's fine. And then it needs to have the date and a date of revocation. So that can be a condition, an event. It could say, this release will be revoked when I am no longer participating in this program, something like that, but it needs to have an end date on there. Again, it doesn't have to be a specific date. It can be an event, but it does need to have like a close. Okay, so I think that is everything. Does anybody have questions about sharing information? Yeah, under part 2.
Hold on one second. We're trying to just grab this for the recording.
So we were talking about documentation-wise. So what is legally acceptable or not? There was a point that we were talking about exchanging emails. So is that legally acceptable? And moreover, this regulation, I'm sure, is regulating an enactment, federal level. So in case there is a conflict, which one overrides? And what is that federal regulation is what I was thinking.
Okay. So when you say emails, do you mean you emailing with, who are the emails going between and what information do the emails contain?
I was just citing that as an example. So remember, during the eviction process, just to clock the time of the 24-hour period, we mentioned emailing, right? Is that acceptable legally?
Yeah, so
and then again, and then again, documentation-wise, if we're documenting all the paperwork, it's going to be one-sided. So, does it have a signature? What are the entails? What does one document require?
Sure. So these laws are limited to sharing health information. Communicating in general, these laws wouldn't necessarily apply. This is really only when you're communicating about health information. As far as, and then, I'm sorry, you had said that the documentation, is that in regards to documenting the notice and discharge?
That is generally any documentation that is required by the fire.
Sure, so that should be kept by the owner-operator, needs to keep that documentation. The documentation might be completed by staff. It's fine if they do that, but that should be kept securely by the owner-operator. Yeah.
There's lots of informal communication between operators. One guy will say, oh, what happened to this person who's in your program? Oh, he caught hot. And so we got rid of him. We discharged him. And so that is hot, right? PHI, right? You tested positive or something, that PHI in that informal setting, it's we're thinking like formal documents, is that still PHI?
It could be.
Back to the resident that this guy or that guy who was relapsed and
Yeah.
based on it, based on your analysis.
Yeah, so under HIPAA, it's only documentation, it's written or electronic. Under Part 2, it can be oral. So it could be, whether that information is protected under Part 2. Yeah, maybe not, because you might not be a Part 2 program. So a Part 2 program is a program that's a federally assisted program, which does include nonprofits. Nonprofit is considered federally assisted. A federally assisted program that treats, diagnoses, or refers individuals for substance use disorders. That's the definition of it. And so if you're a Part 2 program, sharing any information that would identify an individual and their substance use disorder treatment would be considered Part 2 information. So it gets complicated in determining, am I a Part 2 program? Am I covered by this law? You're not really providing treatment or diagnosis. So maybe not. But that's some of the information that you receive, like a UA. That UA itself is probably covered because that's coming from a treatment provider. And so sharing that information, you want to be cautious about it. I would generally advise not to share information even orally unless you have a release. If something is de-identified, so if you're not identifying the person, okay. De-identified information is not covered by HIPAA or Part 2. That's okay. But yeah, I would be cautious about sharing. Yeah.
So my question kind of goes off of that. For instance, like that informal oral communication that happens between owners and, say, a house manager about things that happen in the program are not only to protect said program or residents, but to protect the following residents that resident goes to from experiencing the same thing. So where does that protection for us as a whole come into play?
So if it's within your program, if it's an owner talking to a house manager, that's within the same program. So that you can share information within the same program. It's when you're sharing outside of it that you want to be cautious. And look, there's a lot of issues with Part 2. They've tried to make amendments to it, especially recently. The concern with passing this law years ago was that they didn't want substance use disorder information, one, to be the basis for any sort of criminal actions inappropriately, but also because of the stigma. So there are a lot of issues with it, especially like this, when you're just trying to communicate for continuation of care, really is kind of what we're talking about. And it doesn't, Part 2 doesn't incorporate that like HIPAA does. So HIPAA would have an exception for that situation. Part 2 doesn't. So again, just be cautious. Yeah. Yeah.
My name is Mike. So Scott calls me and says, I've got Bob's application for my program. What can you tell me about Bob? And I can just say he was released for not following program guidelines. Would that be safe? It wasn't a good fit. It wasn't a good fit.
Well, so what you might want to do is at the very outset in your intake forms, intake paperworks, CARR has that Part 2 release form. Have them sign a release form to CARR, to any other houses that you work with. Do that at the outset, and then you have their consent to share information.
Thanks.
Yeah.
I just think this is a little dangerous because if you could have had a guy in your house 2 years ago, you don't know what he's done in the last 2 years to get better, or whether that program would work even though yours didn't. I don't know, guys, be careful, please. Everybody deserves a chance to get clean, and we know it takes some people many times.
Okay, so that's all I had, unless anybody has any additional questions? Yeah.
So the consent, so we have an open-ended consent form, we already have one, we don't have ours right now is completely open, our consent form right now is completely open-ended, so we're gonna have to fix that. So as long as we have a end, not date, but
Condition.
ending event, then it can still be open-ended that we can share with anybody, correct? That, because the line, we leave that blank, as long as there's an end date, is that correct?
It needs to identify who the information's going to. So yeah, it needs who is sending it, you guys, who's receiving it. It doesn't need to name an individual person. It can name a program, a house, car, whatever. And it does need to have an end event or condition.
Okay.
Yeah. Okay. All right. Well, thank you, everybody.
Oh, don't go run off yet.
No.
We're going to open it up. Does anybody have any questions about anything that we've covered from what CARR is doing in 2024 through the end of Dara's presentation right now? Just giving you guys the opportunity to go back and answer any questions that you guys may have thought of. We want to make sure that all your guys' questions are answered.